Okay, so as many of you know, the 2015 Assisted Decision-Making Capacity Act, while it was commenced in December of 2015, it never became fully operational. And the main reasons for that was the need to create a structural framework around it. And the most important piece of that structural framework was the creation of the Decision Support Service. So it was with real interest when I was at a recent conference held by Barnardo's, where I heard the director of the Decision Support Service, Anya Flynn, speak of a go-live date for the Act of mid-2022. So with that in mind, I thought I would look at maybe 10 things you should know about this Act that we're all looking forward to eagerly in 2022. Okay, so point number one I have as government. So the Department of Justice in October 2020 signed off on a costed plan for the implementation of the Act. And at the same time, they transferred responsibility for the Act to the Department of Children, Equality, Disability, Integration and Youth. Point two, I spoke in the introduction about a go-live date. Now, we all know with go-live dates that they don't always happen exactly on time. So what are the factors that might influence this? I have three sort of sub-points here, and they are, there's going to need to be created rules and procedures for court, there's going to need to be an amending act, and there's going to need to be further ongoing stakeholder preparation. Point three is that the Act will abolish and replace the existing wards of court system. Now, while that in itself is hugely to be welcomed, as that system operates under an Act from 1871, which uses the word lunatic, which has no place in 21st century Ireland, it is worth stressing that my personal experience, both as the former president of the High Court and the current president and the judges who assist her, is that they've been extremely conscious of both protecting the rights of everyone that appears before them and also of operating that legislation in a modern way. Point four is that there's going to be a 3-year transition. What does that mean? That means that all of the existing wards of court will have their cases considered within 3 years of commencement of the Act. And consideration means that either they'll be released from wardship or they'll transfer to the new Act. Point five is that there will be a functional test under the new Act. What does a functional test mean? The way I like to think of that is about time and place. Basically, it means that the Act will prescribe that in relation to decisions, you have to look at the particular circumstance of the particular person at the particular time. An example of that would be, does an elderly person falls within the Act, do they understand and could they say consent to the COVID vaccine? Point six, the decision-making under the new Act will operate under 3 tiers. The least intrusive of these will be a decision-making assistant. The next step up will be a co-decision maker. The most intrusive will be a decision-making representative, and that'll be the closest to the current system of committee and wardship. Point seven is about enduring powers of attorney. The plan under the Act is that these will be extended to include healthcare decisions. It's also the intention of the Decision Support Service that there will be a lot more review and supervision of these than currently exists. Point eight is about court. Currently, the vast majority of wardship cases are dealt with in the High Court. The plan under the new legislation is that they'll be dealt with in the Circuit Court. The advantage of that is that there will be much more local access to the court and possibly more access generally in terms of costs of application. Perhaps the downside to that is that there is possibility for perhaps a slight lack of consistency compared to the current system that operates, where you primarily have one judge with the assistance of 2 other judges dealing with all wardship cases across the country. Point 9 relates to detention. It's not intended that the transitional provisions under the Act will apply to detention. So we have to wait and see what's going to happen to those cases and how they're going to be dealt with. Finally, point 10 relates to children. The Act doesn't deal with children in wardship, and this would suggest that the current system, as recently affirmed by the Supreme Court in the JJ case, will continue to have to be used in cases where perhaps hospitals and families can't agree on the treatment plan for a very sick child. Again, while the Supreme Court wasn't thrilled about the legislation being based in the 1871 Act, they still felt that the regime operated by the High Court was the appropriate one because it provided access, fairness, and a method, and an easily manageable, I suppose, method to review the cases on an ongoing basis. Thank you very much for watching this blog. And if you have any questions, please do get in touch with a member of our team.